All right, welcome everyone. Thanks for making the time to be here with us this morning on December 5th, 2025, this beautiful morning. This is the Maddie presentation titled Innovative, Clever, and Fulfilling Approaches to Your ICF. My name is Kara Derringer, and we're joined by Sarah Ahlstrom and Cindy Miller-Reed, Municipal Collaboration Advisors, and with the Municipal Collaboration team. Sarah is our Municipal Collaboration Specialist, and Cindy and I are, again, the Municipal Collaboration Advisors. This morning, we'll focus on the ICF changes. There's a lot of information to go through, so please feel free to ask questions in the chat. And we will have a Q&A session at the end for any of your burning questions. And just a reminder again that the session is recorded, so those Q&A the questions and answers will occur after the recording has been stopped. All right, so recent amendments were made to the Municipal Government Act's Intermunicipal Collaboration Framework requirements relating to mandatory services, arbitration, and the Minister's authority. Today is a discussion about what you need to know when reviewing your ICF. And just as a reminder, this presentation is provided for information and guidance purposes. It is not direction to municipalities, and it is not intended for use as a template, and certainly does not constitute legal advice. We'll be discussing the legislative changes from 2020 to 2025. And just a note that Bill 50, Municipal Affairs Statutes Amendment Act 2025 received royal assent on May 15th, 2025. Little bit of housekeeping here this morning. So the session materials are attached to your calendar invite. Feel free to download those so you can follow along or you have them for future reference. Again, we'll be recording the session and it will be published on the website in the next few weeks. We'll be turning the recording off before the Q&A session at the end. Feel free to put the questions into the chat as we go along or at the end, whatever works for you. And we will do our best to answer your questions as part of the Q&A.
Okay, good morning. My name is Cindy Miller-Reed. I'm a land use planner who has an interest in intermunicipal planning. So I'm going to go through the legislative changes. So this is the Intermunicipal Collaboration Framework, general provisions and major changes. And as Sarah is suggesting in the chat, see your meeting information for handouts related to this. So I'm going to begin by providing some legislative context, and then I'll move into the legislative changes and the requirements for review of your intermunicipal collaboration framework. So as a quick reminder, the purposes of a municipality are listed in Section 3 of the Municipal Government Act. The purposes, the list of purposes includes D, to act collaboratively with neighboring municipalities to plan, deliver, and fund intermunicipal services. And it's from that basis in Section 3 that Section 708.27, which is the purpose of an ICF, was born. So the last point of Section 3 shifts into the purpose of an ICF, and the intent is to work collaboratively to provide services and requires municipalities to work together. So the purpose of an ICF, this is review, it's in 708.27. This has not changed. It's to provide for the integrated and strategic planning, delivery, and funding of intermunicipal services, to steward scarce resources efficiently in providing local services, and to ensure municipalities contribute to funding to services that benefit their residents. Okay, so that being over, I'm going to talk about some common misconceptions with ICFs. So we have a compare and contrast. So on the left-hand side, ICFs are about the cost sharing of services that benefit residents in more than one municipality. They're about negotiating in good faith and making decisions based on data that is shared. It's discussions on how services are planned and provided in the region. It provides completing a summary of how services are to be provided. And it's also about maintaining intermunicipal services that both municipalities agree to. What ICFs are not about is revenue sharing. And they're not about a municipality being forced to partner with another municipality to provide a service intermunicipally when the municipality believes it is better to provide it on its own. And it's also not about changing existing agreements that both municipalities have agreed to. And what we mean by that is agreements for providing services that you've had in place for a number of years and you renegotiate on a regular basis. The intent of an ICF is to not renegotiate all of those agreements. Those underlying agreements lay underneath an ICF. So we've had a lot of questions and concerns about what's been met by the section and that intent. So hopefully that helps a little bit. But the intent is for municipalities to have a discussion about those services, summarize the services that are going to be provided, and maintain intermunicipal services that both municipalities agree upon and find satisfactory. Okay. I'm going to move on next to what happened before Bill 50 and after Bill 50. So just to be clear, Bill 50 has received royal assent, so it is now included in the Municipal Government Act. So where possible, we'll refer to the sections, but this is a summary, and it's also the summary is also on the fact sheets. So changes to the ICF provisions. So before Bill 50, so this was in place for your initial round of ICFs. There was a definition for the arbitrator and for a framework. Each municipality required a framework, except for the members of a growth management board, with the other members of a growth management board. A framework was required to describe the services that benefit residents in more than one municipality, how those were provided, how they were delivered, and how they were funded. And there was a requirement to go to arbitration if you could not resolve and develop a framework. And the arbitrator issued an award based on the required elements of a framework, and municipalities were required to draft and adopt a framework based on the award. After Bill 50, there were additional definitions added. So in addition to arbitrator and framework, there's a definition for what's a mandatory service, what's a cost for intermunicipal service, what is a third-party service, and what does it mean to act in good faith? There are provisions for municipal districts to opt out of a framework with another municipal districts. And there was an introduction of a list of mandatory services. However, voluntary inclusion of other service is still permitted. So we want to make the distinction about that. There is mandatory arbitration on mandatory services only. However, voluntary arbitration is allowed as well. And after Bill 50, there's increased ministerial authority to ensure compliance with frameworks. That's a compliance with an ICF, an adoption of an ICF, a framework, and to create regulations for implementation and the inclusion of capital costs. So again, these are summarized in a series of fact sheets. I'm just going to quickly go through the clarification of terms. So what's an arbitrator? An arbitrator is a person chosen to make a binding decision to resolve a dispute. What's a mandatory service? A mandatory service are 5 areas. We'll talk about those in a few minutes. What's a framework? A framework is a generic term meaning an ICF. It's the cost of an intermunicipal service. That is the operating, capital, and other non-operating costs required to deliver services. What are third-party services? Third-party services are services that are provided by a third party that is independent from the municipality and has its own act or regulation. So that includes library boards, it includes regional services commissions, it includes municipally controlled corporations, and it includes agricultural services boards, among others. Those are just examples. And acting in good faith. So to act in good faith is to act honestly, respectfully, and reasonably, communicating appropriately, sharing necessary information, meeting through authorized representatives, and being willing and prepared to discuss all issues and explain all rationale. Now that we've given you a bit of a background on ICFs, we'll shift into some of the other changes required in the contents of an ICF. And again, if you have any questions, please feel free to put them in the chat or save them until the end. So I'm going to go quickly through what are the contents of an intermunicipal framework or an ICF. So previous requirement to create an ICF and new ICF provisions. So I want to be clear about one thing. All municipalities still require an ICF or are required to have a discussion about an ICF. So previously, all municipalities had to create an ICF with the municipalities that they shared a common boundary with. Members of growth management boards had the option of creating an ICF. And the option was creating an ICF with members of the other members of the growth management boards for things that were not mandatory. So the additions were new ICF creation provisions. Municipal districts can opt out of creating an ICF by agreement with other municipal districts. But in order to do that, there's some specific requirements that I'll go through in a minute. And the dissolution of the growth management boards, so Edmonton and Calgary growth management boards were dissolved, and there's now a requirement for former members to create an ICF and an intermunicipal development plan, an IDP, with a shared boundary unless they meet the criteria above. So what all this means with an ICF is that the ICFs were intended to create a flexible framework for rural communities and for all communities. It allows you to have a discussion about what services are being provided, what services need to be provided, and what would be required for growth in your municipality. And I'm just going to skip ahead to the next slide. So I think I've gone through portions of this already. All municipalities with a shared boundary are still required to create an ICF or at least have a discussion. There is an opportunity for an optional ICF with municipalities that don't have a shared boundary, with First Nations, Indian bands, and or Métis settlements. So there's an optional exemption for municipal districts with a shared boundary. Those can be exempted by joint agreement. So this is not the entire section of 708.28, but it's a summary. But the provisions for municipal districts to not create an ICF is that the municipal districts have to meet. They both must agree that they don't require a ICF at this time. They must publish the reasons why no ICF is required on their website, and they must notify the minister, and that's by the resolution of each municipality being sent to the ICF mailbox. So the ICF mailbox is, the address for it is icf@gov.ab.ca. So anytime there's a notification with regard to an ICF, it is to go to the ICF mailbox. The municipal districts can also revoke the agreement to not have an ICF at any time. Okay, next page. So content requirements. This is where things have changed a little bit. So 708.29 and 708.32, we'll direct you to those. Okay, thanks, Sarah. So if you currently have an ICF, you need to review it in order to ensure that it complies with the legislation today. So that includes or what I would say is generally the contents is the same as they were when ICFs became a requirement in 2018, but more detail needs to be included to complete the following. So you need a summary of services that is to be provided. You need to describe the services that benefit residents in more than one municipality, how the services will be defined, what service levels are appropriate, how catchment areas will be described, how costs will be determined, and how payments will be provided. Municipal services are provided intermunicipally, municipally, individually, intermunicipally, and by third parties. If they're provided intermunicipally, who's the lead municipality? What's the description of the service being offered or provided? How is the service funded? How will costs be determined? And how will payments be provided? And how both operating capital and non-operating costs will be addressed. What's the term of review? The legislation requires a review not to exceed 5 years. There needs to be a binding dispute resolution provision. And there needs to be a transition plan that includes if you have decommissioning of service providers or a change in intermunicipal delivery. So next slide. So what I spoke about previously on the previous slide was primarily what is located in 708, section 708.29. So one of the major changes with with Bill 50 was that there was a list of 5 mandatory services included in the legislation. So intermunicipal collaboration frameworks must address the provision of 5 mandatory services. And those 5 mandatory services are transportation, water and wastewater, solid waste, emergency services, and recreation. So just one thing to highlight, Minister Williams has indicated that the water and wastewater provisions also include stormwater. So that's something to consider. And municipalities may include additional services in their framework other than third-party services. Okay, and we'll talk a little bit about dispute resolution. So the dispute resolution processes, the provisions in the legislation really haven't changed that much. As a best practice, I'm going to go over the 6 major categories of a dispute resolution process, a good dispute resolution process. So I'm moving from left to right on the slides of my slides. So that's how a notice of a dispute will be given. Will it be given verbally? Will it be given in writing? Is there another reason for it? Is there another way that it could be provided? And what are the timelines around those notices? And what causes the initiation of a dispute resolution process? So a dispute resolution process can include negotiation, it can include mediation, it can include arbitration, it can include med-arb or mead-arb or arb-mead, and other. So mead-arb is, Sarah will go into some more detail about what med-arb or arb-med is. Your dispute resolution process will specify how a third party or a decision maker will be chosen and who the appointing authority is. For an ICF, where there's mandatory arbitration required, the parties appoint the arbitrator, and if they can't agree, the minister appoints the arbitrator. So timeline for dispute resolution processes, those are not to exceed a year. So the intent is that the dispute resolution doesn't continue in perpetuity. It has a beginning, a middle, and an end, and it's 1 year. Binding dispute resolution elements. So the dispute resolution process will indicate that the parties are bound by the outcome of the process. And finally, the the dispute resolution process will include a cost sharing formula or how costs will be divided between the two parties in a dispute resolution process. The next thing we're going to move into is cost sharing, which is a major change that was introduced in Bill 50 in this year. So cost sharing, ICFs address the cost sharing of services that benefit residents in more than one municipality. So as stated earlier, they're not related to revenue sharing, but municipalities are expected to negotiate in good faith and to make decisions based on concrete facts. Okay, and next slide, so the cost calculation model. So one of the things added to 708.29, and I would encourage you to look at the entirety of this section, is a provision for a cost calculation model. So municipalities may establish in a framework a cost calculation model respecting costs for intermunicipal services. And as I alluded to earlier, costs include capital, operating, and non-operating costs. And 708.29 1.5 says each municipality in a framework must disclose to the others any information, data, or assumption relied upon in arriving at its proposal for a cost calculation model. Okay. And next we're going to discuss timelines for reviewing your ICF and for the creation of any new ICF since the legislation was introduced in 2017, 2018. And I'm going to turn it over to Sarah Alstrom.
Okay, thanks, Cindy. I wanted to, thanks, Cindy. And thanks for the good overview of the ICFs and the requirements. For the terms of review, this provision is unchanged. So there still is a requirement in your ICF that you have a term of review, as Cindy indicated, and that cannot exceed 5 years. So that doesn't mean that you want to start your review period one day before before 5 years is up, but you'd want to start your review period before then, so that any changes or modifications to your ICF could be completed by them. During the review period, the goal is that you're working with your municipal neighbor to talk about what changes you might want to make, any additions, any modifications into the next version of your ICF. And if during that review you determine that the framework currently in its current form doesn't suit the interests of your municipalities, then you do create a new framework, and that new framework then you would need to notify the minister once that replacement framework has been created. For further clarification, the MGA has changed a few times over the years. And in 2023, there was a one-time ministerial order extending the review period from 5 to 7 years. And that was to accommodate the anticipated changes to the provisions that you now see in the updated Municipal Government Act. That is a one-time only provision, which expires on March 31st of 2027. So if you didn't have a previous review period and you were able to extend it, then of course you would need to have a replacement framework reviewed by then. The other thing to consider, though, is because of the new provisions regarding mandatory services, a lot of some of your ICFs may not actually meet the current legislative requirements for an ICF. So as you're going through your review period, making sure that the next version of your ICF Act is compliant with all of the new provisions. And if you have any questions, please put them in the chat or we can bring them up. What we did was we did create a little bit of a visual so that you can kind of see how the review period interacts with the dispute resolution provisions or the mandatory arbitration provisions in the legislation. They generally remain the same. So if we say, use an example, that your review period is March 31st, or your review period ends on March 31st of 2027, You have, like, say, starting last month, November of 2025, is when you would spend time from then till the 2027, kind of discussing negotiations, mediations, anything that you need to do to review or to make sure that your ICF is compliant with the updated legislation. If you agree, if you're following the pink arrows, then you adopt the ICF by bylaw or resolution, and you notify the minister at the ICF mailbox. Once we have received both municipalities, so ideally you'll CC each other. Once we receive notification from both shared boundary municipalities, we'll confirm that the ICF is complete. If you're unable to complete your ICF or there's no agreement reached on the mandatory items that are required in your ICF, then you're required to go to mandatory arbitration. And that is where either you can choose, the municipalities can choose who the arbitrator is, or the minister can appoint an arbitrator who will then work through those disputes with you, come up with a resolution where the arbitrator will make an award either in regards to resolving the dispute. But the arbitrator also has expanded capacity or requirements within the new legislation that the arbitrator can also or is required to create an ICF related to the award that resolves the dispute. Once the arbitrator does create that ICF, the municipalities are to adopt them by bylaw or resolution. So that's a bit of a change. And I'll talk about that here in a little bit more detail in the arbitration section. Oh, which ironically is right now. So the previous arbitration provisions, so I know only a handful of municipalities actually had to go through arbitration since this legislation has been enacted. The previous arbitration provisions was that the arbitrator could hear any service-related disputes. So any disputes that municipalities had regarding an intermunicipal service, the arbitrator had the jurisdiction to hear. The arbitrator would then issue an award to resolve the disputes. The arbitrator could consider any matters that they felt were relevant, and then the municipalities would take that award and translate it into an ICF that would be adopted. With the new provisions, the arbitrator still hears the disputes, but the mandatory arbitration is around mandatory services. So if it's a mandatory service, it must go to arbitration. If it's an optional service, then it's optional what decision or what process you'd like to follow. The arbitrator still issues an award to resolve the disputes. However, the arbitrator also ensures the creation of the ICF. So the arbitrator has expanded responsibilities to make sure that the ICF is created. So not just resolving the dispute, but actually ensure that that framework agreement is created. The other pieces that kind of change the arbitrator's jurisdiction is that the arbitrator can no longer has a jurisdiction to consider all matters they think is relevant. If the municipalities have a current agreement between them that you still agree to, there's no dispute over it, the arbitrator cannot change or contradict that agreement that you have. The other piece that restricts the arbitration or the arbitrator is that the arbitrator cannot consider any matters that the municipalities have not previously discussed. So if you want to bring a matter to the arbitrator, you must talk to each other first. So if there's a dispute, if there's something that you disagree with, you need to talk to each other first before you can refer it to the arbitrator for a decision. So that kind of goes with the previous around negotiating in good faith. Have those conversations with each other. So now what's generally in scope for arbitration is the mandatory services, costs related to delivering mandatory services, capital costs for new facilities, for the delivery of mandatory services, still resolving disputes between municipalities, and ensuring an ICF is created. Just for greater clarity, the arbitrator cannot negate any matter already agreed upon unless it's outside of the municipality's jurisdiction. So if it's something that's not within the jurisdiction of a municipality, then the arbitrator would be able to have say in that. Like I said, a matter not previously discussed with municipalities, and the arbitrator cannot make a binding decision on non-mandatory services. So that's something that the two of you, if there's a service that say you agree on, that you would like to have included, both municipalities would like to have, it's not in a mandatory category, but you still would like to have an arbitrator make a decision on some kind of details of that agreement, then you can still agree to go to arbitration to get those areas of dispute dealt with, and then choose to include that in your ICF. Any questions related to that? That's a lot on the arbitration stuff. Okay. Yeah, Carrie, it's okay. We can go to the next one. Still monitoring the chat if anyone has any questions. Generally, the arbitration also applies. So the arbitration applies for creation of an ICF, but it also applies in disputes that arise from your ICF. So that still applies. Ideally, if you have an ICF and you have a conflicts dispute resolution process in there, you would ideally follow that first. And if you're unable to get resolution to that dispute within 1 year, then you can refer it to an arbitrator. If it is a mandatory service, then it would still be subject to the mandatory arbitration provisions. And so a dispute could include interpretation, application, or of your ICF as you go through the process. The Arbitration Act still does apply to arbitration, except where it's modified by the Municipal Government Act. And the Municipal Government Act, for clarity, does take precedence over the Arbitration Act. One of the things that is probably important to note there between the Arbitration Act and the Municipal Government Act, or the MGA, is that with the Arbitration Act, municipalities are able to decide the scope and be able to voluntarily participate in arbitration or not. Because of the mandatory provisions within the MGA, municipalities cannot opt out of those. So if you have to go to voluntary arbitration through the MGA, that means that you must proceed. You cannot opt out. That would be previously allowed in the Arbitration Act if it was voluntary. The role of the arbitrator, like I said earlier, has kind of somewhat expanded and somewhat contracted. They're still required to make an award. The arbitrator hears the parties and makes a binding decision based on the criteria in the legislation. And for further clarity, if you're looking at 70838, you'll see the arbitrator does have some requirements talking about public interest, environmental concerns, equitable cost sharing between municipalities, things of that nature. So those are some of the things that the arbitrator may consider when you're presenting your side. The arbitrator is now required to make an award. And the municipalities, so the legislation is very clear, the municipalities are then required to adopt the framework that is created by the arbitrator within 60 days of you being provided the ICF that was created. The other piece to note is that, well, I'll talk about it in the minister's authority section, but the arbitrator also now has the ability to not only send you as a municipality the ICF and the award, but the arbitrator also has an obligation to send that to the minister as well. So the minister will get a copy of the arbitrator's award at the same time you do. All right. And for further clarification, because I know there is some confusion being that arbitration is a relatively small used dispute resolution process, is that you do have significant roles as a municipality in an arbitration process. very similar to any other hearing that you would go to. Your role is still to prepare your case and gather evidence. So it's your job to be able to clearly articulate what is it that are your areas of concern, get your appropriate legal advice, and prepare any documents or reports that you would like reviewed. Then the process is similar to any other hearing. You exchange your documents. When the hearing is held, you get to argue your points of view to the arbitrator. There is an ability for cross-examination or to be cross-examined during the hearing process. So making sure that, again, that you're well prepared and providing the information that the arbitrator needs to rely on to make a decision. The arbitrator then has a period of time to write the award and then issue it to you. And then you have 60 days to adopt the ICF. And the other piece that we get questions a lot about is around the arbitrator or the arbitration costs. So generally, the cost for the arbitrator is shared by the municipalities, and the MGA does provide three different options for how costs may be shared. Generally, and ideally, in your dispute resolution clause, you'll have an agreement for how you want to share the cost of an arbitration. You can ask the arbitrator to include in their award how costs are going to be distributed, or the third option is that it's a proportional basis based on equalized assessment. So ideally, as you're negotiating your ICF, you'll have, Kara, can you just go back one more second? You will have figured that out. The minister has expanded powers to order a municipality to pay for their portion of costs for the arbitration. Otherwise, there's sanctions. The other thing to be clear, and on the last piece, is municipalities only share costs for the arbitrator or the arbitration process itself. For the preparation and participation costs, each municipality must bear those yourself. So whatever you need to do to prepare or to participate in that arbitration. That being said, the arbitrator also has an ability to award costs if requested during the arbitration process. And so if you're going to arbitration, strongly recommend that you refer to your legal counsel on best advice for preparing and what that might mean for you. Thank you. And I'm going to turn it over to Cindy to talk a little bit about the changes to ministerial authority. Cindy?
Okay, thanks, Sarah. So the last major change in Bill 50 was a change to minister's authority. So again, on the left-hand column, previous ministerial authority, the minister's authority was limited to creating or opposing the adoption of an ICF by municipalities only in situations where an arbitrator was not appointed. The minister could take any measure under section 708.43 sub 3, such as withholding grants. I'll get into that more in a few minutes, but the new ministerial authority, so the minister has expanded authority to make any order they consider necessary or advisable for the implementation or compliance with a framework. And if the minister takes any actions under 708.433, they must provide reasons to the municipality for why they are taking such measures. So as an explanation, feedback from municipalities and the municipal associations when consultation was occurring on ICFs in 2024 suggested that the minister be provided additional authority to ensure that an ICF is created, that the municipalities are complying with the ICF. And if the minister decides to use this authority, as I indicated, if the minister decides to use the authority, reasons have to be provided. So what's changed is that if the minister believes a municipality hasn't followed a framework or the binding arbitration decision, or it hasn't adopted a framework that reflects the arbitrator's decision or the ICF that was provided by the arbitrator, the minister can issue an order requiring the municipality to do so. Okay, and on the next slide, I'm going to talk about the regulation making authority. So I'm going to bounce around a little bit, but there's regulation making authority that was added as part of Bill 50. So previously, the Lieutenant Governor and Council could make regulations regarding subsequent actions before the court regarding the decision of an arbitrator, defining any term or expression in Part 17.2. That's the ICF provisions in the Act, and any other matter considered necessary or advisable to carry out the intention of Part 17.2, the ICF portion. The minister could not make any regulations. So what's changed and added in Bill 50 is the Lieutenant Governor and Council has expanded authority to make regulations on the implementation of an ICF adopted as a result of an arbitration. And the minister has authority to make regulations in relation to the inclusion of capital costs in an ICF. So what this also means is that there are currently no regulations in place, so no specific action is required. And I just want to go into, just checking my notes, I just wanted to go into a little bit of extra detail on ministerial orders to ensure the implementation of ICFs. So previously, the Municipal Government Act indicated that previously, even if municipalities had gone to arbitration and an award had been issued, but no ICF was created, the minister did not have clear authority to ensure the implementation of an award and the creation of an ICF. What's changed is that amendment allows the minister authority to make orders about anything that is required to support the purpose of the ICF provisions, including the implementation of a framework. And if the municipality fails to comply, the minister has measures that he can exercise under 708.43, which includes withholding grants and other measures. But if they choose to do that, they have to provide reasons. Okay, and the minister's authority to enforce an ICF. So as I indicated, we're jumping around a little bit. This is section 708.43 sub 3. This is the minister's authority to enforce an ICF. So if a municipality fails to adopt a framework or an ICF, or comply with an award, or adopt a framework that reflects the award, the minister may take any necessary measures, such as imposing a framework reflecting the award on the municipality or using other tools. Those other tools, there's an extensive list in 708.43 sub 3 that says necessary measures include, by order of the minister, suspending the authority of council to make bylaws or respect any other matter specified in the order, exercising bylaw making authority in respect to any or all of the matters to which bylaw authority is suspended under the clause is suspended, removing the suspension of a bylaw making authority with or without conditions, withholding money otherwise payable by the government to the municipality pending compliance of the award with the order of the minister, imposing a framework on the municipality reflecting the arbitrator's award, repealing, amending, or making policies and procedures with respect to the municipality, suspending the authority of a development authority or a subdivision authority, and providing for a person to act in place pending compliance with the conditions specified in an order, requiring or prohibiting any other action as necessary to ensure the municipality complies with the framework. And as I indicated earlier, if the minister issues an award or exercises any of these powers, they must provide reasons to the municipality at the time that they issue the order. I'm going to flip this back over to Sarah. She's going to talk about dispute resolution options.
Thank you, Cindy. Just give me 1 second. I just noticed that there was a Q&A question regarding clarification on MDs and exemptions. And so I'm going to answer that, hit enter here, and then we can always bring that forward in the Q&A section. I just can't do two things at once. Okay, so thank you. So for dispute resolution options. So ideally for those people who have created their ICF, they would have some dispute resolution options already in their ICFs. Just out of curiosity, and a test to see who's actually online live, can I see reactions or thumbs up from people who need to create an ICF from scratch? Just to see if we have any of those folks here. Okay. I see one. Anyone? So then I'm assuming just by reaction, everyone else, we're just doing kind of a review and an updating of your ICFs. Oh, I love seeing the bouquet of thumbs. Okay, thank you. So for the dispute resolution, so it'll be a quick review for you folks. And for the ones who are doing brand new ones, we'll just kind of, this will be a little bit new. And then again, for the review folks, you might want to consider if your dispute resolution process does not include these elements, that you might want to think about that in your next iteration. So generally speaking, what happens if you don't agree? There are kind of 5 general categories of ways that disputes are resolved. So that could be facilitation, it could be mediation, it could be the MGA does allow for med arb to happen, and I'll talk about that in a second. It does allow for voluntary arbitration, as alluded to earlier in the presentation, as well as mandatory arbitration. So I'm just going to walk through a few of these just so you get a better kind of idea why you might want to explore some of these options or include them into your dispute resolution provisions in your ICF. So another way to look at this from a process perspective, facilitation is kind of that informal problem-solving negotiation piece. Mediation is when you're actually there's an actual active conflict. So facilitation kind of works really nice to help kind of guide the conversation. And then if you see on the right-hand side, we're moving into arbitration, litigation, and legislation. So those are kind of the dispute resolution areas in which you would, as municipalities, have less control over the decision-making. Whereas in the earlier ones, you would be able to have control. Of course, it costs less because you're not necessarily involving lawyers. And it tends to be a relationship builder rather than a relationship harmer. Because usually once we get into a litigation type situation, we find that the relationship is damaged because the dispute has gone on for such a long period of time. Okay, so negotiation. That's basically where you work directly with your neighbor. You don't usually have anyone directly intervening in that. It's really nice when the services negotiated are simple and straightforward. And I think someone's already asked in the chat, you know, if we already have agreements in the mandatory categories, can we just reference them because there's no disagreement we don't want to change? Absolutely. So if your relationship is high trust, you are able to reach agreements, you have no major issues, then by all means, it should be the ICF creation process or review process should be quite simple for you once you decide who your negotiation teams are. The next one is the facilitation. So that's where you might want to consider having a third party come in to help guide the conversation. They don't typically tell you what to do specifically about the issues that you're talking about. They're relatively neutral on that. What they are is more of a conversation guider and to help kind of control the meetings, help set agendas, deal with the logistics, those kinds of things that a lot of municipalities find very helpful. And as a program area, we recommend facilitation if there are a number of issues. So say you haven't talked about these mandatory categories yet, then you might want to have facilitation if you know that it's going to be complicated, you're going to need extra expert information, that kind of stuff. You might want to have someone to help guide that process for you. And definitely highly recommended when you're creating an ICF from scratch. So that's kind of the advantage of a facilitator. When you use facilitation or mediation, which I'll talk about here in a second, there is grant funding available within our program area to be able to help offset the costs for those folks to come in and provide assistance to you. So mediation is kind of the next piece. Just out of curiosity, did anyone use mediation to create their ICF, or is anticipating using mediation for their review process? Okay, I got one. Okay, there might be more of you out there. Absolutely. Mediation is basically mediation. A mediator is just a specialized facilitator that helps deal with more contentious issues or more challenges that municipalities have. So if you know it's going to be contentious, if you know it's going to be a bit of an issue, or there's going to be a lot of things, and you've got, say, a new council or an old council, or you have historically challenging relationships with your municipal neighbor, you might want to have a mediator come in early into the process. Maybe start like right off the bat, starting the convening process, helping each municipality to decide who's on your negotiation team. Again, doing similar things to the facilitator, like scheduling, that kind of stuff. But the mediator can also help when emotions get high or the conflict starts arising between the municipalities. So again, always recommending mediation first if that's something that you think would be helpful for you. And there is, like I said, some grant funding available to help offset the cost of mediation. Now, if you get past, if you're not able to negotiate, your facilitation or your mediation didn't result in agreements that you're looking at, then it moves into the arbitration, or just to help kind of bookend this, a quasi-judicial board like the LPRT to help make a decision for you. So you've kind of exhausted all of the comments that you've had all the conversations that you can have, but you still fundamentally disagree, or you can't come to an agreement on a specific provision or a detail around a service. Then you would refer it to arbitration, or in the case of anything planning related, you would send that to the LPRT. So what they'll do is they'll hear the situation and they'll make a decision for you. As municipalities, if you're going to arbitration, you have to pay for the arbitrator costs. The LPRT is you don't have to pay for the board members, but you still have to pay all your preparation costs and anything regarding legal advice or experts information that you're looking for. The challenge with that is that currently there are no provincial grant funding available to assist with arbitrations or preparing hearings to go to the LPRT. So we do provide that earlier intervention piece support for you. Generally speaking, with negotiation and mediation versus arbitration of the LPRT, negotiation mediation is lower cost for the mediators and lower cost for preparing. The mediators can help you with that, and your use of or your requirement for legal advice is lower than if you go to the arbitration. The nice thing about negotiation and mediation is as you're going through those discussions and those difficult conversations, it tends to build better relationships and stronger relationships between the municipalities as they go through it. Mediation can be a confidential process, so all your negotiation conversations can be confidential, with an agreement and an understanding that all decisions made for municipalities must be done in public. So there will be an agreement set out at the beginning as to what is shared with the public or the media and when it's shared with the public or the media. Another that important that you maintain control of the agreement and the conversation throughout the negotiation mediation process. But one thing that's also important to note is that even if you don't come up with a resolution with mediation or negotiation, so if you resolve it, great. That's ideally the goal. And I think within our program, we're about at an 85% resolution rate for municipalities that do go to mediation. If it doesn't go to mediation, what it can also, the mediation process can do is to help actually narrow down what are those outstanding areas of dispute. So if it needs to go to arbitration, what are those things that you want the arbitrator make a decision on? So it saves that scoping exercise can already be done. And with some of the LPRT disputes, they will require a mediator's report as to what are the areas of agreement and disagreements. So the mediation process can help you narrow those things down. Within the arbitration process, the arbitrators are generally more expensive than the mediators. Most arbitrators are also lawyers. The LPRT, as well as the arbitrators, can attribute costs for the hearing or not. It's up to their individual jurisdiction as to whether costs should be provided. It is a much more adversarial process. You're not really talking to each other. Typically, parties or municipalities will be talking through their lawyers to the arbitrator or to the panel members, providing their case, doing the cross-examination, that kind of stuff. The nice thing about arbitration or the LPRT is that you do get a binding resolution to the issue. So they will make a decision for you that will be binding on you. So that's something that you'll get that level of certainty. And it can be helpful if it's a very specific, narrow issue that you can't resolve. It can be quite an efficient way to deal with those pieces that may allow you to go back into mediation, which I think the next. Oh, do we have? Oh no. So the other piece, and that kind of brings me to the extra point, where the MGA does allow any mediator who's assisted the parties to potentially act as an arbitrator. So if you know that an arbitrator can act as a mediator, so that's called med-arb. If you're in a situation where, as the two of you going in, as the partner and municipalities are going into their renegotiation process or their ICF creation process for the few that are still on the creation side, if you know something is going to be contentious, like say, for example, you agree that recreation should include that recreation is important. We both agree that we should partner on recreation, but we either don't agree on what services or what facilities are going to be included, or we don't agree on the cost funding formula. So just like you agree that this is what you want to do, but some of the details are a bit of an issue. You might want to consider actually looking into a med-arb process at the beginning, so that there's a transition, a nicer, smoother transition if you need decisions made on certain things, but you'd really like to negotiate the rest and have control over the rest of those elements of your ICF. Any questions about any of that? I'll keep monitoring the Q&A as well as the chat. Cindy, I'm going to turn it over to you to talk a little bit more about what our program can do to help support you with your ICFs.
Okay, thanks a lot, Sarah. And just a footnote, I can't see the Q&A or the chat. So for any questions that come up in there, we can address those at the Q&A, which will happen after we talk a little bit about our program. So our program is called Municipal Dispute Resolution Services, but we as a team are municipal collaboration advisors and specialists. The program, next slide, please. The program includes intermunicipal dispute resolution, the collaborative governance initiative. We do advisory and conflict coaching supports, and we provide education. So a quick thumbnail of what this program does: intermunicipal dispute resolution includes convening and information sessions. So we are able to provide information sessions to municipal councils or staff to talk about any of our program areas or what supports might be helpful to them. We can provide joint and regional convening sessions to provide information and best practices for collaborative projects. That service under intermunicipal dispute resolution allows for multiple attendees to get the same information and to ask questions they have related to potential projects. Collaborative governance initiative is another aspect of our program. We do protocol development, including things like ICF, intermunicipal collaboration frameworks, development, and intermunicipal development plans. We provide funding for mediation services where two or more municipalities, or a municipality and a regional entity like a school board, a regional services commissions, or a Métis settlements are wanting to negotiate and would like the assistance of a neutral facilitator or mediator. The role is to help the parties move forward in a collaborative way to reach an agreement that's mutually beneficial. Sarah alluded to this earlier, but a mediator doesn't tell you what to do, but they help to guide a process to allow discussions to happen, and hopefully for municipalities and parties to come up with a solution. Facilitation, we provide facilitation support to parties. Our grant program also provides that. And we have, as part of the intermunicipal dispute resolution process, we have a roster of arbitrators and mediators and MEDAR practitioners that is available on our website for anyone to use. I should highlight that this program has existed for 27 years. It started initially as intermunicipal dispute resolution as mediation was included in the Municipal Government Act in 1998. So on collaborative governance initiatives, these are for things like internal organizational projects or intermunicipal projects where two or more municipalities want to investigate or explore options for regional development, regional service delivery. Advisory and conflict coaching supports. We provide information coaching and referral services based on individual conversations on a particular situation. Any advisory or conflict coaching calls are confidential and are available at any time by talking to one of us from the program. Education sessions. This is also outlined on our webpage, but we have a number of training and workshops that are designed for communication and conflict management and capacity building. There's a long list on our municipal website, and I won't go into those, but basically the three streams are negotiation, workplace, and public input. Next slide. So resources, you can reach any one of us on the team by calling 780-427-2225. That's the Municipal Services Division main line. You can check out our website, which is Municipal Collaboration and Mediation. You can also click on the link in your presentation. Our team email is long, we apologize, but it is Municipal Collaboration, all squished together and as one word, at gov.ab.ca. And as I indicated earlier, we maintain a mediator and arbitrator roster and MedArb roster that we develop in conjunction with our advisory committee. So our advisory committee is comprised of all of the municipal associations, the Canadian Bar Association, the ADRIA, the ADR Institute of Alberta, and Society of Local Government Managers. Next slide. So for anybody that's interested, the most current version of the Municipal Government Act can be found online at the King's Printer. If you click that link, that gives you the most current version. And if you're interested in what Bill 50 said exactly, there's a link that will take you to the Legislative Assembly page that will give you the final the final wording of the bill. Okay, and as I mentioned earlier, our webpage for municipal dispute resolution is the first one. ICF's is the second webpage. Mediator and arbitrator roster as well. And there's a mediator handbook that we produce that if you're interested and need some pointers on how to choose a mediator or a med-arb practitioner or an arbitrator, you can use that. I think Sarah probably included there were a number of fact sheets that were developed by our team after Bill 50. The other resource I'll point you to is the ICF workbook. So the workbook is online. The link will, if you click on the link on our webpage, it will take you to the RMA webpage. This is the 2020 version. It does not include the 2025 legislative amendments. There is an updated resource that's coming. We are working on updating the legislative portions that are located in the first 20 or so pages of the original workbook. Sarah alluded to this earlier. Thanks, Sarah. Sarah alluded to this earlier. Our grant falls under the falls under the Alberta Community Partnership. It is the Mediation and Cooperative Processes Grant. It is open. It is a continuous grant. So it opens when the minister approves the grant program. It closes February 3rd. And it will cover a number of things. I would encourage you to take a look at the grant guidelines. If you have any questions, the phone number on this page is for the grants advisors. So 780-422-7125 will connect you with the grant advisor. And so for facilitation and mediation of an ICF or for collaborative governance or anything else, you can use the mediation and cooperative processes stream. That is a cost shared grant. Municipal Affairs contributes a third. Professional fees and travels of mediators, a third of the cost. For mediation, it's up to $20,000. For protocol development and ICFs, it's up to $50,000. For the intermunicipal collaboration stream, that is the IC grant. That is a competitive grant that is handled strictly by the grants advisors downstairs. It closed about a week ago, but that one is up to $200,000, not cost shared, and it is for completion of studies and other things. With the community partnership, the mediation and cooperative processes stream, essentially one partner, one municipality agrees to be the banker and administer the grant and the funding. And that brings us to the questions. So again, if you have any questions, please feel free to ask them.